Welcome to the Republican Professor. Today we have with us Jason Pye. Did I say your name right?
You did.
With Due Process Institute. Thanks for being here, Jason.
Thanks for having me. I appreciate it.
Well, I'm my only connection with you is like on Instagram, and I don't even remember what post it was that I saw that I started following Due Process Institute, but whatever it was, I liked it, and Um, I've had the thought like I'd like to cover this set of topics, criminal justice stuff at some point. And now let's get this on the record. You're not an attorney, right?
I am not an attorney, no, but I am a
Oh,
lobbyist, which I'm not sure which one's worse.
so your stock went up and then it went right back down.
That's
Just
right.
kidding. Wow. What's it like being a lobbyist
um,
for you?
well, you get a lot of weird looks. I'm originally from Georgia, and uh, my previous job, I spent 6.5 years at FreedomWorks, which is a conservative libertarian organization based in Washington, D.C. I would
Hmm.
actually commute from Atlanta to DC. I was probably 38 to 40 weeks out of the year. And so I still had my friend group back in Atlanta and Metro Atlanta. And I mean, these guys, most of my friends back home knew I was the quote unquote good lobbyist, meaning that I was a limited government advocate and philosophically libertarian, and was working to cut spending, cut taxes, among other things, cut regulation. And so they didn't frown upon my job. They still don't.
Hmm.
But there is a negative connotation that comes with being a lobbyist, and it's
Yeah.
frustrating to say the least, because people will say, well, lobbyists are bad because they have so much influence over members of Congress and so on and so forth. They're corrupt, blah 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 blah, and we ought to put more restrictions on lobbying. And a lot of people, my response is always, well, the First Amendment protects lobbying. No, it doesn't. Yes, it does, because it says we have the right to redress our grievances. That is,
Ooh.
redressing our grievances. One, it's protected speech just generally in the confines of the First Amendment, and two, what do you think redressing our grievances is?
Hmm.
In whatever way, shape, or form those grievances might be shaped. That is what I do. Is I just happen to be paid to redress grievances.
Yeah.
But I was at FreedomWorks September 2014 through February 2021, and left for bipartisan pastures at the Due Process Institute, where I've been ever since. And it's a fun job. It's highly stressful.
Really?
Yeah, I mean, one of the things
What's
I
stressful
can't.
about it?
Well, one, I mean, I actually have recently had a couple people come to me asking for advice about, they wanted to pursue a career in advocacy. And my response was like, this is a great job if you don't mind losing a lot.
Really?
And yeah, because, well, that's the fact of the matter. I mean, you know, um, any given year you'll have, Due Process Institute. I've probably worked on a few dozen different bills,
Mhm.
and we've had some successes, but those successes have been limited. Um, and a lot of it's because of the hyperpartisan atmosphere in which we
Yeah.
currently live.
Right.
And
Okay.
it makes in everything we do is bipartisan, and there is bipartisanship on the issue of criminal justice, but
Hmm.
it's but there's so much hatred and bitterness and anger directed from one side or the other. It makes it really hard to sort of break through the hyper partisan nonsense that we see on any given day in Washington D.C. So that's why it's like,
Yeah.
you have to learn to live with frustration, and you have to
Okay.
also learn how to leave it at home when work is over,
Yeah.
or
I
leave it at
see.
work when work is over.
Right. So Due Process Institute is a nonpartisan. a- Is it a lobbying group or is it?
Yeah.
I thought it was like a think tank.
So Due Process Institute is we are an advocacy organization. We are the way we
Okay.
brand ourselves is we focus on bipartisan. We're lawyers and lobbyists for the Constitution who focus on bipartisan solutions that
Okay.
will reform the criminal legal system.
Gotcha. Okay. So what was it that got you interested? What do you think the most interesting part of your work is there?
Oh
I guess
man,
there's actually two questions there, but I don't want to give them both at the same time because I don't want to overload you. But
oh,
like
you're
the first
fine.
one was kind of like a biographical thing, like what
Yeah.
drew you into it. But the second one,
Well,
you can take whichever one you want. And first, the uh, the question of what is most interesting to you about what you do.
so I think the thing that's most interesting to me about what I do is seeing just how I guess it's a multi. I guess there's multiple answers here because
Okay.
there are so many different facets to what I do. So
Yeah.
one thing I've always loved doing is reading legislation and learning legislation. Because there's so much in that you deal with on a day-to-day basis. Um,
You like reading
so
that stuff?
yeah. No, I actually had an
And
office
these are
email me.
proposals, right? They're
Yeah,
not
these
law. Yeah, okay.
Yeah, these are proposals. And like this morning, for example, I had a Republican office on the House side. Actually, they emailed me last night, but I didn't get to look at their bill until today, this morning. And I was reading through it, and I'm going through. He's asking for my opinions on it. And if you read the surface of the bill, you're like, I mean, I guess some of the sense, and then you start going and comparing it to what's currently in code because they were amending the U.S. code, and I'm like, a lot of the same concerns we had in other bills are still present in this one. They're not as bad, but they're still present. So that's one aspect of it. Just you learn a lot, and I feel
Mm.
like my knowledge on these particular issues, has just grown exponentially since I started working at Due Process Institute. The So that's one part. The other part is, going and lobbying and meeting offices, because not every office, like these offices are not like a monolith. Each one has different concerns and different constituencies, and
Yep.
whether they're in the district or outside groups, whatever the case may be. So you're going in and you're meeting these offices, and you find that, like, and one, you find the staffers. This will come as no surprise, I think, at least to your listeners. These staffers often have their own agendas, and
Oh yeah.
that was that was something I learned very early on when I
Of
started
course.
doing lobbying. But just how often stark it is, I think, is the one thing that kind of caught me off guard. It wasn't that they
Mm.
had their own agenda; it was just more of like, wow, you're in a completely different place from your boss. Because like
Mm.
I've talked to your boss and I know where your boss is.
Mm-hmm.
So that's it's just meeting the
That's
offices, learning the
interesting.
staff, meeting the staffers, learning what they care about, learning what they're interested in. And also
Yeah.
just, yeah, I mean, this is not a prestige thing by any stretch of the imagination. I got to tell you, some of my favorite days are just going over to the Hill and just going and sitting down between my meetings, like in one of
Yeah.
the cafeterias or one of the
Yeah.
coffee shops that are on the Hill, and just like
Yeah.
watching the people who walk by, because you see
Yeah.
all cast of characters walk by in these during these days. So yeah, that's I mean, there's multiple
So
things, but that's
you like getting to know people.
it's yeah, I
You
think
must
I
know
think
a
that's
lot of people. You
I
probably
do,
know a
I
lot of
do.
people.
I do. My it's my girlfriend and her younger brother, often will send me tweets from people. The two of us are the three of us, I should say, are on a text thread together. And her younger brother, there's a 22-year age difference between her and her younger brother. So
Wow.
he's 20 years old. We're both 42.
Is
And
that even biologically possible?
well, same father, different mothers.
Oh,
Um,
yeah.
so um, so
Yeah.
but no, they'll send me tweets from people, and I'm like, oh, I know that guy, or I know her, and they're like, of course you do, of course you know that
Uh-huh.
person. So it's like
Yeah.
it's almost a daily occurrence, but
Yeah.
it's I do know a lot of people, and it's just I enjoy good conversation, no matter what it's about. You and I could sit here and talk football for the rest of the day, or talk baseball for the rest of the day, and I'd be happy. I enjoy good conversation. I enjoy
I don't know if you'd be happy with my ability to keep up with you in those conversations because I don't have much on that.
No, it's fine. Like the thing that I think I find most fascinating about meeting people, meeting staffers on the Hill. I gave a speech or a talk back January of last year, and one of the things I was giving a presentation about was, well, I was giving a presentation about advocacy, but one of the things I talked about was there are tricks that I have at my disposal. Not tricks. Tricks is the wrong way to frame it. Sounds like I'm pulling one over on someone. I'm not. Um, there are various ways I find to make a staffer feel comfortable, and it goes from anywhere, like, where are you from? Just asking. Well, I've been. Let's say you're from Nashville, Tennessee. And I'll go into some, because I've been to Nashville. It's like I make that connection and start talking about Nashville and my, where I've been when I'm there, and
Yeah.
or what sports teams they follow, because I'm well rounded enough in baseball and college football to discuss it. NFL, not as much, but I still know enough. Music is always one that I love to talk about with staffers because I'm a musician in my spare time.
Oh, that's cool.
Yeah, and so those are ways I find to get in with a staffer, to make them feel comfortable, to make them feel like they can let their guard down around me, and I'm
Well,
not
that's
like
what
I'm not
business people do. I know a lot of
right.
business people, and they're always like looking for some kind of connection.
Yeah, making a connection is vitally important,
Yeah.
and whether it's someone from the South or someone from some city I've been to, there's always a way to make a connection, and that's something I've really found is a useful tool in my job, and like I said, it's probably saved me from getting thrown out of a couple offices. So
Yeah, I bet. So when you're reading these legislative proposals, um, do you have something you're looking for that you want to see, or is it kind of the thing where you're not totally committed about what you want to see exactly, and
so
you're just kind of learning? I would imagine that you have something like you're looking for that's good. So
yeah, I mean,
what would that be if that's the case?
so it depends on the proposal. Some legislative proposals we get that we want to look at are pretty straightforward. We know what they're doing. Because a lot of what we deal with is are amending current code sections, especially on the criminal justice side. So it's going to be something in Title 18 dealing with criminal penalties or incarceration or what have you, or Title 21, which is the Controlled Substances Act. So you're
Okay.
looking for specific changes, tweaks to the existing code or amendments to existing code. So those are all things that we kind of look for. But there are more complex, like the one I got this morning, that is a more complex proposal that you have to go on the surface. It looked fine, but you have to go into the code itself and see the detail, because they're going back and making all these references to existing code. So you have to go back and compare existing code. So one thing, this might be interesting to your listeners. I don't know how I see the Golden Gate Bridge behind you, so I'm assuming you're in California. I don't know how California does it, but Georgia and many other state legislatures, when they introduce a bill, it goes through legislative council, they draft you a bill. And what they do is if you're amending a code section, they put the whole code section in, and they strike through what you're repealing out, and then they replace it with new text that's underlined. They don't do it like that in Congress.
No.
So it can be confusing.
Yeah, that's true. Well, you
Former
also have to
Congressman.
kind of know what the code means, like in
Yeah.
practice. Like,
Yes.
what's the code for?
Yeah. I mean, you have to follow all those sorts of things. Former Congressman Justin Amash, when he was around, introduced a bill called the Readable Legislation Act that would do bills just like they did them in state legislatures.
That's a good idea.
And I really wish that piece of legislation would get adopted. The framers and founding fathers talked about how legislation should be easy to understand, law should be easy to understand, but Congress makes it way more complex than it
Right,
should be.
right. Yeah. So when you hear the term due process in the name of your organization, what does that mean to you? Due process. What does it mean, and what should it mean? Does it mean
Sure.
something that doesn't quite match what it should mean?
No, not for us. I mean, due process. So we the concept of due process goes back centuries. I mean, this is something that was in the Magna Carta. This was something that was discussed in Blackstone's commentaries. This was something that, maybe, so that's English common law. We due process means that a person, at least in our constitutional constraints, talk about the Fifth Amendment, talk about the 14th Amendment. Due process means someone has the right, especially in like a criminal trial, to have their case heard, has the right to be innocent until proven guilty. And then we have other amendments like the right to a speedy trial, right to a trial by their, a jury of their peers. All things fall into the category of due process. So there's been a lot of discussion today about George Santos, the congressman from New York,
I saw that today.
who has been indicted on 13 different counts of criminal activity, everything from wire fraud to money laundering to lying to making false statements to the House of Representatives, and so on. In the eyes of the public, because of all the news coverage he has gotten, because he has told so many lies, I gather that he doesn't even know what the truth is. He is still innocent until proven guilty. The government has to make a case that beyond a reasonable doubt that he is guilty of all of these or one of these charges. And so in the eyes of the law, and really in the eyes of the public, regardless of what he said or how much of a liar he has made himself out to be, he has to be presumed innocent. And that's one element of it. Then you have something like there is and this is a good example of what we mean by due process. And under current federal law, if you are, let's say George Santos, let's use him as an example. Let's say that he's convicted of one of these criminal offenses. A judge, based on a preponderance of the evidence, meaning more likely than not, may sentence him.
That's a different standard than for the jury.
That's right. The jury has to decide beyond a reasonable doubt, or conclude beyond a reasonable doubt, that he's guilty of a criminal offense. But after the verdict's been reached, a judge may, according to federal law, use his behavior to give him a more lengthy sentence, even if he was acquitted of those charges.
I like where you're going with this. Yeah. Okay.
We call that acquitted conduct sentencing, and it is a severe violation of our constitutional order. So much so that you had a few years ago, several years ago, I should say, you had Justices Scalia, Thomas, and Ginsburg each sign a dissent. Someone had applied for cert for one of these cases, for an acquitted conduct case, and the court didn't hear it. And Scalia, Thomas, and Ginsburg each signed a dissent, basically blasting the practice of acquitted conduct sentencing.
That is officially bipartisan right there.
That is officially bipartisan. And look, that we worked on that bill. There is a bill. It hasn't been reintroduced in the current Congress, but we expect it to be reintroduced in the current Congress that would get rid of the practice.
What's the main problem with that, if you could put it?
Well, I mean,
what bothers you most about it?
Well, what bothers me most about it, this would be conduct for which a jury of someone's peers found them not guilty or did not convict them for. So,
Right.
but
So they're
by
innocent of that.
exactly, that's exactly what I was going to say. By all intents and purposes, they're innocent, and you have a judge taking his authority unconstitutionally to impose a heftier sentence on someone
Right.
based on a preponderance of the evidence for conduct that person is acquitted of, and giving them
Yeah.
that flies in the face of due process.
Mm-hmm.
And look, we are, one way or another, that practice will end. The question is, does Congress do it or do the courts do it?
All right. So for all the non-criminal defense appeals lawyers out there, which is most people, and you know, I I'm I'm going to edge on the very borderline of my understanding of these things pretty quickly, although I did have an aspect of my dissertation on this exact issue right here with the sentencing guidelines. But just so people know, there are sentencing guidelines in place that are put forward by a commission. So, and the commission is not Congress. It's not it's not the White House. It's not, it's like one of those independent agencies, quasi-independent agencies. And we could
It's the
debate about whether they
U.S.
should even exist or not, right? But
It's the U.S. Sentencing Commission.
U.S. Sentence Commission, yeah. And it's so these guidelines establish a range of discretion for a judge, and there's some good reason to have that range of discretion for a judge. And we could get into that. You know, I'd like to hear what you think about that. The range of
Sure.
discretion. What's the pro argument for that? But there's this con, and the con is what you're saying is that it seems like the judge can abuse that discretion by doing something that looks like it violates due process, which is you're not supposed to be punished in this country, treated like a criminal for conduct that you not only are presumed innocent of, but you actually have been acquitted by a jury. You're officially innocent, meaning you can't be tried again for that. Double jeopardy, right? That would
Yeah, no,
violate
that's
double jeopardy. So, but then the judge can, by a different standard, not beyond a reasonable doubt. So it failed reasonable doubt. There was a reasonable doubt for that conduct. The judge can swoop in there with preponderance of evidence, which is a much lower standard. It's like 51-49. You know, if reasonable doubt is, what would you say reasonable doubt is? 95.5? I don't,
not
something like
reasonable
that.
doubt is reasonable doubt is a 99.9.
99. Okay.
That's what I would
I'm
say.
not even sure what the percentage is, but preponderance of evidence is nowhere near the
Yeah.
90%. It's like 51%. Did you, it's like, and so the judge can go, well, yeah. I mean, what's a good example? We're talking about someone that's been charged with multiple things. So the government is throwing like 10 things at them, and maybe one or two things stick.
Yeah.
And so the other 8, they didn't really have the evidence. They
So
just were trying to scare the guy or whatever. But then the judge can go, well, there was some evidence, and yeah, so I'm going to give you the max of the sentencing guidelines. Whereas, like, you know, we're not talking about giving sentences outside of the guidelines, right? We're talking about within the guidelines. If you got those two, the range would be, if you were in the middle, I don't know, let's say it's 2 to 5 years, and it would be normal for a judge to give you like 2.5 years or whatever.
yeah, I mean the guidelines. You got to remember the guidelines are prescriptive. They're not. They are since the Booker case, I think in 2004, they have been
right.
purely prescriptive. That's it.
Gotcha. Okay.
So yeah,
So the judge is bound by them, is what you're saying.
well, no. The prior to Booker, the judge was bound by them.
Prior
But
to Booker. Okay.
when Booker came through, and this was 2004, 2005, I don't remember the exact year.
Yes, that's right.
The guidelines have been prescriptive, except in cases where Congress has required a mandatory minimum sentence. So if you've committed
Gotcha.
a drug felony, like a trafficking felony that carries a 5-year mandatory minimum sentence, you are going to get at minimum 60 months.
Okay.
And based on, and judges have to take in a number of different aspects when determining a sentence. It's prior criminal history,
Right.
the nature and circumstances of the offense, whether you have accepted responsibility for the offense. There are a number of factors that they have to take into consideration
Okay.
to determine the length of the sentence. So if you're in a situation where you're a category 1 offender who has little to no criminal history, the chances of you serving, unless there's a mandatory minimum, the chances of you serving a lengthy sentence are likely low, depending on the offense.
I got an example. I think it's good to give an example. Thank you for that, by the way. So the Booker decision, that's a Supreme Court decision. I think you're right. I think it's like 2005. I
Yeah.
can't remember who was in the majority on that. It seems like it was a 5-4 thing, if I recall right.
I don't remember off the top of my head. I mean, I've referred to Booker several times, but I haven't looked at the opinion probably in a year and a
I
half.
remember needing to read it a few, and there's actually a couple different ones, if I recall right. There's a Booker one, and then there's another one that's kind of important. I'm not sure if there's
Yeah.
two Bookers or not, actually. But okay, so now stay with us, people, because this is a little bit convoluted, but I promise you there will be this very clear, interesting thing at the end of this little thing that would be very important for us to think about. It's a little bit technical right now, but it's going to get really clear, and there's going to be a happy place of understanding, I think, after, and you're going to have something to talk about at cocktail parties, and which is the whole point of the whole thing, right? But you know, there was a case in the DC circuit, and a while ago, and it was this guy that had been under investigation for drug dealing, and he got 5 years. He got 5 years, which was, I think, the max penalty for making a false statement on a postal signing form or something. But it was so that's what they got him on. They threw everything at him, and none of it stuck. But during the investigation, he had signed for a delivery of a package like Fred Flintstone or something. And that's what they got him on, was a false statement. And and I remember thinking to myself, that is incredible that you could. I don't think most people know that signing Fred Flintstone on a delivery package is a false statement, federal offense, like 5-year minimum or whatever. And he got the max. I don't know if it was 5 years, but it was whatever it was. It was like the max of the sentencing guidelines.
Jeez.
And so this issue came up, and I was like, in my research, and I was like, I got to really think about what I think about this. This is a little complicated, because the impression is this: the cops know he's guilty, the investigators know he's guilty, and sensitive juries kind of pick up on this, and they just kind of go with whatever the cop says, because they just believe cops, right? They're like, oh, well, he was arrested, so he must be guilty. Well, that's not actually what you're supposed to do as a juror. You're not supposed to do
right.
that as a juror, because you could be wrong and the cops could be wrong. They have made mistakes before, and they make mistakes every day. They're just people, and judges can be wrong. And sometimes people get, so yes, this guy could have been a total dirtbag, but you're telling me that he signs Fred Flintstone or whatever on the receipt for the package. It's not what was in the package that got him the sentence. It was what he put his name on. And a testimony of the postal delivery carrier person.
No,
you got to be kidding me. That's what gets you 5 years. I mean, that's certainly not with normal prosecution, right?
No, I mean, it's situations like that are I'm not familiar with that case. But situations like that are on the probably extreme end, and maybe that person had, something else in their criminal history, or that necessitated a longer sentence. But I don't know. But situations like that are, look,
Hmm.
when you're dealing, like, go think back to the um confirmation hearings for Ketanji Brown Jackson. Did I get it right? Yeah. So there was a lot in those hearings about the way she had sentenced in child pornography cases. And this is probably not the best example, but it is an example because it shows was that judges, and this is just kind of like highlighting the guidelines issues.
Okay.
Judges were sentencing below the recommendation that the guidelines suggested, like frequently. But this was happening. This wasn't just in it wasn't only her doing it, was other judges doing it too. And
why were they doing that? What was
one,
because
one, I don't know the specific reasons, case by case instances. I don't know the specific reasons. I didn't look at any of the individual cases. We weren't engaging. I was watching
was it
the
a
hearings.
policy thing? Like they don't believe this should be criminal conduct, or was it?
I think no. It wasn't that. It was more along the. I'm struggling to remember the specific details. So basically, it was a situation where it had become standard practice in federal courts, if memory serves, to give us, instead of giving the guideline recommendation, it was to give a lower amount of time in prison. Now, these people were still going to prison, but there may have been mitigating circumstances. Maybe, and I again, I want to stress here that I don't remember any specific details from any of these. We were not engaging on her confirmation, but we don't engage on any nominees. But if memory serves, you might have had situations where someone themselves, like someone who was accused of doing this, was themselves experienced sexual abuse as a minor, and situations like that. There are different things you have to take into account in sentencing any type of offense, not just these.
Right.
But it had become common practice in federal courts to give less than the guidelines recommended.
Okay.
Well, one of the things we were pointing out, like, well, we weren't pointing this out, but one of the things a lot of people were pointing out on Twitter and so on was that Congress has the power to create a mandatory sentence for these offenses if they want to. Now, that is a whole process. That is not something that is easy to do.
Right.
But Congress, if they want to blame anyone, they should blame themselves, and because they have known since 2005. And the Booker decision, by the way, was a mishmash. I went and looked it up after you asked me about it. That there were dissents and opinions all over the place. And Scalia, for one example, joined the majority in one place and then had his own dissent in another place. It was pretty interesting. But Congress Congress can fix that. And it's not something they should blame any judges for, other than not having clarification on how they need to do this, and the guidelines being, if memory serves, I think the guidelines were kind of like a jumbled mess as it comes to all that stuff. And look, I say that as someone, you ask, the reasons I got into this. I mean, I have plenty of them, but one of them is, I have 2 sexual abuse survivors in my family, and a recovering drug addict in my family, and these are immediate family members. So, there's some you have to take in consideration victims and what victims' needs are, and you also have to take in the consideration the backstory of people who even are involved in any sort of criminality, especially drug addiction. So
sure,
yeah,
I totally get it. Yeah, I'm with you on that. I want to just really quickly, for those of you who are a little frustrated trying to follow my postal package story, the case I just found it's United States versus Moore, 612 in the 3rd volume of the Federal Reporters, starting at 698, DC Circuit 2010. And it's actually not really a, a sentencing guideline issue. It was a mens rea issue, but that's kind of
Uh,
a due process issue too. We could get into that.
100%,
Yeah.
100%.
Yeah. Brett Kavanaugh was actually the judge in that, one of the judges on the 3-judge panel
Yeah,
then.
the mens
And
rea,
yeah,
go, mens rea.
he was complaining that there's no mens rea. You can't establish he meant to, had criminal intention when he
I
said
think when
drug
it
kill
comes to
some.
the acquitted conduct sentencing issue, just to close the loop on that, I said that whether the court does it or Congress fixes the issue, it's going to be addressed. I think we have the votes on the court right now to address the acquitted conduct sentencing issue. Mens rea is an entirely separate issue, and it's one that doesn't get a
Yes.
ton of, it's not, and yes, it is a due process issue. You can go back to Johnson versus United States.
The
The
flag.
Supreme Court, no, this was a 2015 case related
Okay.
to the Armed Career Criminal Act. So they had in the Armed Career Criminal Act had a residual clause that was meant to capture. So basically, like the Armed Career Criminal Act is basically for repeat violent offenders, individuals. I think so. Basically, it's like the 3 strikes law for violent offenses or serious violent felonies. I think serious drug related felonies, if memory serves. So there was this residual clause that talked about other behavior that may be deemed violent. And in Johnson, and I don't remember the specific ins and outs of the Johnson case. Even I wrote a paper about this years ago. It's I think I wrote that in 2015, another lifetime ago, as it were. But ACCA, the residual clause was like it gutted ACCA. It was like the second or third time ACCA had been gutted by the Supreme Court in some way. And so basically, it's like this vague description of other behavior that wasn't specifically defined, that had no real parameters on it other than it has to have some tangential connection to a potential violent offense. So there was a case, this was separate from Johnson, where someone had found, they were pulling up carpet. Senator Mike Lee talks about this case some, or has talked about it some. You have this case where a guy was pulling up carpet and found a bullet. And this guy had 1 or 2 prior violent felonies, found a bullet. Now, he had no gun. He didn't have, it wasn't his
Yeah.
bullet. And he was prosecuted.
Is this the Johnson case you're talking about?
This was separate from Johnson.
Okay.
But what Scalia called Johnson, this residual clause issue in Johnson, he called it he called the Armed Career Criminal Act a farce playing in courts throughout the country, because of the way ACCA had this, because of this residual clause, and because it failed to provide fair notice to individuals, because they didn't know that things they might have done could be considered a criminal offense. And this kind of goes to the broader point. So there's a guy by the name of Mike Chase, who, in full disclosure, serves on Due Process Institute's board. He wrote a book a few years ago, pre-pandemic. It's like an illustrated, I think it's called A Crime a Day, an illustrated guide on how to become a federal criminal.
Wow.
In any event, go to Amazon.com and look up Mike Chase.
Okay.
And Mike clearly, like, he runs the Twitter account Crime a Day. And I think he said that if he were to post one crime in the federal code or in the federal code of regulations, or the code of federal regulations, that each day he would be at it for like 800 years or something like that. So, but
Wow.
we every day we engage in behavior that we consider mundane and not important, that could be considered a federal crime. And Harvey Silver, there's a guy, author by the name of Harvey Silverglate, who also wrote a book called 3 Felonies a Day. He posits on the theory that the average American commits 3 felonies a day, often, without even knowing that they're committing a felony.
Okay, so let's camp out there for a sec, because that's raises an issue that I think would be great for get your thoughts on. What's the problem with that? Let's say somebody's listening to this and they're thinking, Jason, I don't see the problem. They're not charging people for 3 felonies a day, and it's kind of like parking on the street when you're not supposed to park. You get away with it typically. Maybe you get a parking ticket every once in a while. But what's the problem with that? What's the problem with having so many laws that you can just your daily life, you break them every day?
There's a LSU professor by the name of, I think his name is John Baker. And by the way, I'm sorry if you hear some noise in the background. I have a cats and they are playing with toys.
Okay.
Um, so John, I think it's Professor John Baker who once said, and this is a very profound statement. He said that not one person in the United States, 18 or over, well, basically every person in the United States over the age of 18 can be prosecuted for a federal crime. It's a profound statement, and that's because
and that's not hyperbolic.
It's not hyperbolic.
It's real. As
it's
the kids
real.
say, it's literal.
It's literal. Yeah. As my girlfriend's 7-year-old daughter says, actually, it's literally true. No. So no, you are. We don't really know, and this is part of the problem, and because we don't know the full extent of the problem, we don't know what behavior may trigger. Like, you don't have to. Yeah, you're right. They
fair
are
notice.
Prosecutors aren't charging people for routine mundane stuff every day, but they could.
Okay,
they could.
That's it right there. That's it.
They could. We don't know how many laws are
based on their discretion.
That's right. We don't know how many laws are on the books currently. The estimate is that there are 5,000 criminal statutes in the U.S. code. But
insane.
But there might be as many as 300,000 regulations that carry criminal penalties. That means regulations that have
growing.
Regulations that have been promulgated and published in the Federal Register by agencies with rulemaking authority that tie back to those criminal penalties.
Right.
And so there's a great example of and I may forget the ins and outs of all this one, but this one deals with like the US, like the Migratory Birds Act. You had this woman who had found a baby woodpecker, and she saved it in like her driveway. She saved it from the family cat. He was about to eat it. I see where this is going. She's shopping in the local grocery store, and a U.S. Fish and Wildlife official approaches her and basically arrests her. You have another situation where you have a guy, and this is one of the more famous ones. We have a guy who's and he works at a retirement home in Washington, D.C., in Northwest D.C. So you can imagine vulnerable patients. The retirement home is vulnerable to flooding, and sure enough, they have an instance where there's flooding and sewage backup, and he follows SOP and releases the sewage into Rock Creek, which is a creek that runs in the middle of Washington, D.C., but it's a tributary to the Potomac River. So he was prosecuted for violating the Clean Water Act. He didn't know where the water was being sent. He had no idea, but he was prosecuted for this.
So that's a fair notice. That's a fair notice issue, right?
Right. And last I heard, the Wall Street Journal did a story on him several years ago. Last I heard, he was mopping the halls at Gallaudet University, which is a university for the blind and deaf in Northeast Washington, D.C. So you have situations. Can you explain
what fair notice is? Why is fair notice important? And why do we kind of take it for granted?
It's basically like the knowledge that you may be engaging in behavior that carries criminal penalties or could be punishable
ahead of time, right? You got to know about it ahead of time before you've already done it. So
being punishable by actual prison time or a fine or some sort of mark on your record.
We've all heard the phrase, ignorance of the law is no excuse. And it's like, okay, you could drive a Mack truck through that because
Yeah.
That's a fair notice issue. You're supposed to
Yeah.
have fair notice. That's part of due process.
And so in mens rea for its intent. So there's
Right.
there's actus rea, which is the act of committing a crime, and then there's mens rea. Did you operate with intent to commit a crime? And we have various levels of mens rea. There's knowledge, there's willful, there's reckless disregard. There's different levels of mens rea that and prosecutors hate it because it requires them to do their jobs where they actually have to
Right.
prove that you did do something
Right.
that met the knowledge requirement in federal law.
Yeah.
And the problem that we're seeing is a trend that we've seen in federal criminal law where Congress is becoming more and more reliant on what we call strict liability, meaning there is no
Right.
mens rea.
Yeah.
So
That's a
so in
problem.
some yeah, that is a problem. And sometimes courts will read in a mens rea
Yeah.
into a statute, but that's
Yeah.
but the absence of fair notice, the absence that you might be engaging in some sort of behavior that is a crime. Like
Mhm.
let me. This is a stupid example. Let me give you an example. So, my girlfriend's daughter is 7 years old, and she loves Taylor Swift. I don't like Taylor Swift. She loves Taylor Swift. It's not my cup of tea. I do like one song by her though, and that's that stupid "Shake It Up" song. Um, if I were to go, and this is the closest thing I can come to getting myself in trouble. If I were to go and record a cover version of that and
Mm.
fail to give her credit or
Mm.
whatever, not maybe I just forget to do it. I don't know.
Mhm.
Let's assume there's some sort of criminal penalty for that or civil fine or whatever. It didn't matter whether I intended to do it. I'm not aware of any criminal penalty. Did I truly break the law? And that's the thing. If you commit the act and you're not aware and you haven't been
Right.
provided fair notice
Right.
of the act being a crime, are
Yes.
you truly guilty?
Yeah. Okay, I love that setup. Let me give you another example that's an actual. I'll just go back to the postal thing because I found in my dissertation where I talked about it. So I'll just I'll read part of I have part of my dissertation on the Fifth Amendment. Judge Kavanaugh wrote about I'm quoting myself here in my dissertation. Judge Kavanaugh wrote about the due process demands of mens rea and finding guilt in administrative and criminally liable conduct. It's just a paragraph. Don't worry. The first such case that Kavanaugh addressed was an opinion in United States versus Moore. That was a federal drug case that ended up with no conviction on the drugs. Ah, but the feds did make a false statement charge stick. Okay. The individual who's being investigated was shipped a U.S. postal package by investigators containing what investigators believed he thought were drugs. And he signed for the package with a false name. Now, this is Kavanaugh. This is me quoting Kavanaugh. Unlike many government forms, the form contained no warning that an inaccurate statement might be a crime. And it's not otherwise clear that more or most people would know that signing the wrong name on a postal delivery form is a crime. Kavanaugh began. So that's the end of the quote for Kavanaugh. This is still me. And this is the key point to his concurrence. This is Kavanaugh again, quote, but the defense did not request a knowledge of the law instruction, and the district court did not require the government to prove the defendant knew his conduct was unlawful. So the issue was not preserved for appeal. Now, this is interesting because I don't think most people know that that's a crime. And if it doesn't say it's a crime,
Yeah.
how could you have fair notice? And the point, we're linking fair notice with mens rea. And this is all part of due process, historically understood in our tradition, the Anglo-American legal tradition, that if I don't know that's a crime, how could I have a criminal mindset when I engage in that conduct? And
That's
how
right.
could I have mens rea? And if those two things are, if mens rea is required for criminal conduct, which historically it is, with maybe a couple exceptions, and fair notice is required for due process, and both are required for due process, we got a major constitutional problem. And we also have a problem with like just basic morality, because
Yeah.
we all know that it's not, we know kind of what's fair and not fair. Like when you're dealing with kids and a kid gets in trouble, the kid didn't know what he was doing was wrong.
Right.
That is usually enough to mitigate the severity of the punishment of the kid, right? I mean, if the kid
Mhm.
doesn't know, now if you tell him, like, don't throw rocks at cars when they're driving by, and I mean, he should have known that, but now you're on fair notice, you do it again, and he's doing it again. Well, okay, there's mens rea, right? Unless the kid has a
Right.
mental problem or something, like a real, like, learning disability or something like that.
Right. No, there's really good, and this is again not a segment of the population that is particularly received a lot of sympathy from most Americans, but um, although I would argue they should to some degree. You There was a markup last year of a bill that we worked on, and it's called the Kenneth P. Thompson Begin Again Act. And so what this bill does is super simple, it's super basic, and it's really common sense. Um, to my knowledge, in federal law, there's only one expungement statute at all, but there's one specifically. This one is specifically designed for simple possession of a controlled substance. The catch is you have to be under the age of 21 to be eligible for that expungement. So all the Kenneth P. Thompson Begin Again Act would do is take out the age restriction. It would make it available to people of all ages.
Okay.
Common sense piece of legislation. And during markup in the House Judiciary Committee last year, Republicans did what Republicans do, and they made it all about fentanyl.
Hmm.
They offered an amendment. It was Congressman Mike Johnson of Louisiana who offered an amendment that would exclude fentanyl. When we say exclude fentanyl, we're not talking about some, just like a hit of just pure fentanyl or whatever. We're talking about like,
Anything that has fentanyl in it.
that's correct, right? So even trace amounts of fentanyl. That would be considered simple possession of fentanyl, even if it has just a trace amount of fentanyl.
Hmm. Okay.
So,
Does that pretty much gut the proposal then? Like,
not, I mean, it hurts it, yes, but does it completely gut it? No, not necessarily. It just hurts it. So
okay.
the problem with that is, if you're a user,
Mhm.
one of the reasons we've had so many opioid deaths or fentanyl related deaths is these synthetic opioids, is because users don't know what's in the drugs.
Yeah.
And unfortunately, societally, there's a certain class of people who looks down on things like fentanyl testing strips, or safe injection sites, or whatever it may be. So
Mhm.
these people can't can use drugs safely. And we can get on a whole tangent about those issues, and I'm happy to do it. But Congressman Matt Gaetz, who is not someone I usually agree with especially, look, I have a Republican conservative background, but Matt Gaetz is often interesting to say the least.
Mhm.
But he offered an amendment to Johnson's amendment to basically say, to require a knowledge requirement, to have a knowledge requirement. You had to knowingly possess a drug that had fentanyl in it.
That's a lot
And
harder to prove, everybody, just
a
FYI.
lot harder to prove. And especially because, like, if you're a user, again, unless you have access to, say,
Right.
testing to testing strips, or to or using a drug at an injection site where those testing strips would be available, whatever the case may be, you don't know what's in that drug.
Yeah.
So, and then the
Yeah,
amendment
that's
was
interesting.
they adopted Gates's. They changed the amendment to
Well,
more to
good for
Gates's
him.
liking. Yeah, no, but he specifically referenced like mens
Good for
rea
him.
being such an issue here, and he's
Yeah.
right. And we do have Chip Roy. So there was a bill several years ago called this. Well, the bill's still around. It was reintroduced already this Congress. It's called the Smarter Sentencing Act, and there's a
Okay.
section of the Smarter Sentencing Act that would require the federal government, the Department of Justice, to actually make a complete list of all federal criminal statutes, their maximum penalties, how many times it's been used, so on and so forth, as well as all regulations that carry criminal penalties. The same stuff required to make it publicly available online, so everyday Americans can go and look at it and see what behavior is potentially criminal. We've managed to get Congressman Chip Roy to introduce that as a standalone proposal, meaning it's separated from the rest of that Smarter Sentencing Act proposal on the House side. He's done that. It's bipartisan. He did that with Hakeem Jeffries in the past two Congresses. We're hopeful that we might be able to see some movement on that in this Congress. But that's something that several years ago, the House had the House Over-Criminalization Task Force. It was chaired by Jim Sensenbrenner, Bobby Scott from Virginia, my adopted home state. It's where I currently live, and a bunch of other members. This commission, this task force, 2014, 2015, 2016, something like that. They asked the Congressional Research Service to put together this list of criminal statutes, and CRS came back to the task force and said they lacked the manpower needed
Oh
to
my
put together
goodness.
this.
Wow.
Yeah, that's how much of a
There's the
cluster you know
clip.
what
There's
it
the
is.
clip for Twitter right there for this
Yeah,
episode. That's insane. That's not surprising. With my students, I don't know so much about the other faculty, but with my students, and I'll bet that that other faculty, most of them don't understand this either. Uh,
yeah.
have no idea, one, how big the government is. In fact, I'll bet you that the average person elected to president doesn't know how big the government is until several years into it, and they're supposed to run the damn thing. But so that's one issue. But related to all these agencies, they all do something, and they're all prohibiting something, and oftentimes those prohibitions come with criminal penalties. It doesn't matter if it's energy or if it's interior with the fish and wildlife. You pick up an eagle feather, well, you're now a federal felon because you picked
One
up
of
an
the
eagle feather. You didn't even know it was an eagle feather, but even if you did, there's nobody around and you just want to have an eagle feather on your bookshelf. Next thing you know, it's on Instagram and you're in handcuffs or whatever. I mean, they
yeah,
could charge you, not like they would, but they could.
good. I mean, it's frustrating because we've had this debate over the past few years over policing, and one of the things that people don't seem to understand when, because like what's the number one reaction when we have some sort of public nuisance or we view as a societal ill or whatever the case
Right.
may be? It's there ought to be a law.
Yes.
That tends to be where
That's
everybody
that's
goes.
that's good. I like that. I like where you're going with this.
Where whenever we create a new law, especially one with criminal penalties, we are basically saying it is okay for the government to use force at the point of a gun
Yeah.
to enforce this law.
That's gun violence, by the way,
We
for everybody
we
keeping track.
we are creating interactions with law enforcement. Now, this is on the federal side, but states have their own laws,
Sure.
and states,
Yeah. It's the
you know,
same thing.
whenever you ask a lawmaker to pursue a new criminal penalty,
Mhm.
You are asking for more police interactions,
Yeah,
and
absolutely.
and yeah, and
What could
that's something.
possibly go wrong?
That's exactly it. And the reason Chip Roy introduced that bill, he introduced that bill at the height of the congressional debate over policing, and their thinking was, if we want to address this issue of policing, we should know where we're sanctioning interactions between law enforcement and people. Because, and it all goes to the over-criminalization and over-federalization of federal criminal law. There's a lot of stuff the federal government has on the books, crimes the federal government has on the books, that should be solely enforced at the state level.
Like what? Like, give me an example.
I can't, not off the top of my head. You put me on the spot. Maybe I shouldn't have said it. But look at, I would say something like, drug laws are a good example of it. Every single state has its own Controlled Substances Act.
Right.
Every single state has its own Controlled Substances Act. Some states like Oregon, they handle it differently. Oregon has, I think they've decriminalized, trafficking still remains illegal, but they've decriminalized the simple possession of controlled substances. Right. So, but every state has this, and this is sort of like when you look at the federal criminal system, particularly the prison system, you're talking about 175,000, give or take on the day, prisoners. These are people who are incarcerated and we consider that incarceration means they're in a high security prison, medium security prison, federal prison camp, whatever the case may be. So states, on the other hand, state prison populations, again, on any given day, 1.5 million, 1.7 million. States should be largely running these issues and taking these issues, not, and I understand that there are jurisdictional issues if someone crosses state lines, things like that.
Right.
But drug laws at the federal level are largely, in my 2 cents, pointless, because states bear the brunt of this anyway.
Gotcha.
That's my 2 cents. But
yeah. Well, my understanding is that the what's been called the police power of the state, which is a kind of a technical term for people that are not into this constitutional law stuff, but it's been federalized through the Commerce Clause, typically, in the Constitution. So there's like now a federal police power. There's always been a federal police power to some extent on like federal land, like territory, or like on military bases, for example. It's still illegal to kill somebody on to murder somebody, I should be more specific, or rape somebody in a federal building. I mean, that's kind of a police power thing. But the difference between the feds and the state, I'm not sure from a due process perspective. What does it matter from a due process perspective? Is due process better protected at the state level?
I don't know that due process is better protected at the state level, and because when it comes to acquitted conduct sentencing, I mean, you'd have to have
right.
I think that gets a little tricky. One, you have, I think it also looks at, you have to look at where this gets way down in the weeds.
Sure.
You have to look at where you believe the Bill of Rights applies. Now, from our perspective, the Bill of Rights applies both to federal citizenship and to state citizenship. But so if when the due process clause, it's been incorporated, so the states would have to protect due process. But there's, I think, I haven't researched this enough to know my is really the expert on acquitted conduct sentencing. But there is some belief that the history of acquitted conduct sentencing might go back into unsavory areas of American history, like the same way that gun laws would go back to unsavory aspects of American history. If those of you who don't catch my drift, I'm talking about Jim Crow. So
Now everybody that's listening to this is very excited because they're waiting for you to mention guns.
well, I mean, gun laws. I
My
mean,
friends are my everybody that it's involved in this project are like Second Amendment people. And the drug issue, you know how Republicans are with drugs, just kind
yeah.
of take it or leave. I mean, we're listening to the libertarians. I mean, we hear you. But then like the libertarians start mentioning the connection with firearms and drugs, and all of a sudden everybody's paying attention. Like, oh
Well,
yeah, a
you
simple
have
possession. Oh, now I know what you're talking about.
well people because the frustrating thing to me, as I mean, look, I'm a gun owner. I only own one gun. I own a 9 millimeter, but and it's just for home protection. Believe me, I'm aware a 12 gauge shotgun is better for home protection. Um, but and with a 7-year-old roaming about the house, trigger locks are necessary. So uh, look, um, when it comes to discussions, especially right now, when it comes to discussions about crime, fentanyl, so on and so forth, I think and I consider myself politically homeless at this stage of my life.
A lot of people
Um,
do. Yeah,
yeah, and growing too.
sure.
So
Makes my job fun.
yeah, but it does. Republicans frustrate me to no end because I agree that there's an individual right to gun ownership created by the Second Amendment. I agree with Heller and McDonald. Um,
Yeah.
but Republicans, in particular strong Second Amendment conservatives, don't seem to grasp, and Democrats do this too, and it's just the reverse. Um, you We have seen tremendous gun liberalization in the states over the course of the past 10 or 15 years, right? We saw the expiration federally, we saw the expiration of the assault weapons ban back in 2004. And since
Right.
that time, we've seen a tremendous growth. My home state, Georgia, where I'm from originally, just created a constitutional carry. And I don't,
Well, I'm in California, so
you have
I'm
no gun rights.
well, every inch is a battle.
No,
Yeah,
I imagine so, but
it is. It's
you
constant.
you
It's constant.
but we've also seen at the same time, um, especially in the past few years, that there has been a rise in gun violence, gun related violence. Now, if you ask me, Jason Pye, I would tell you that violent crime rates are half of what they were at their peak in 1991. That violent crime, while has gone up in recent years, it is far from an epidemic. Um, I would tell you that the National Crime Victimization Survey shows no measurable increase in victims of gun related victimizations. There is data to back that up.
More people are
Just
killed with fists and feet than rifles and shotguns of all kinds, according to the FBI.
what I would say is Republicans have to be very careful about the crime narrative because um, because of what we're seeing on TV. Gun related school shootings, so on and so
They get the
forth.
headlines. Those
They
things
get the
get
headlines.
some of them do. Well, let
Yeah,
me revise my statement. Some of them do.
yeah. But but you have to be very careful when you're talking about crime if you're a Republican, because it's very easy to say um, that if we only had gun control, these school shootings wouldn't be happening as often. Or if we had red flag laws, these school shootings wouldn't be happening as often. If we had an assault weapons ban, these shootings wouldn't be happening as often. Um, because
Usually, it's not Republicans saying that. Usually,
well,
these
Republicans, I'm sorry,
these days.
Republicans have to answer the questions.
Gotcha.
They're
Yeah.
put in an uncomfortable space of having to answer those questions as states have consistently liberalized their gun laws. And liberalization for this conversation means making them
Classically liberal. Yeah.
classically liberal, right?
Yeah.
Which is more how I identify myself than anything else. But
Right.
it's my pronouns are classical liberal. So
Okay.
it's a very careful thing that Republicans have to keep in mind here. Um, it's just you have to, and look, from the left, you also have to keep in mind that um, you know, banning
So
guns disarm. Go ahead.
no, I was going to ask you, you're saying that there's wider implications of the correct Republican stance on guns, that they're not making the connection to other things like drugs and stuff. Is that what
Yeah,
you're
they're not
saying?
making. Yeah, they're not making a connection that that gun liberalization has also correlated. I'm not correlation doesn't necessarily equal causation, but it has correlated to an increase in school shootings, at least perceptions, I should say, of increases in school shootings
Perceptions, sure.
or mass shootings. And I think in
Well,
terms of
the most liberal gun laws that we've ever had, like
Mhm.
nationwide, are correlated with virtually zero gun violence in schools. And that's, I mean, Lee Harvey Oswald ordered his rifle like in a Sears catalog or something. I mean,
I'm
talk
I'm
about
not
liberal,
making.
talk,
Yeah, no, I'm
but
not.
that there were
I'm
no
not.
school shootings.
Right. I'm not making an argument for increased gun control here. What I'm
No,
saying
I
is
know, I know.
Republicans need to be careful about how they choose what hills they're going to die
There's,
on.
yeah, that's right.
You can't
I
make the
agree with that.
argument. You can't make the argument that crime is going up, and then also make the argument that we need more gun liberalization. That the Second Amendment is my concealed carry permit, and not expect to get pushback as the number of school shootings, or at least the perception that school shootings are going up, and the number
Yeah,
of mass shootings are going up. You can't, those arguments are like oil and water, and that's where I would tell my Republican friends, conservative friends, be very careful, because you're talking out of both sides of your mouth when you start saying things like that. Do we need to address crime in the United States? Yes, we do. There's a way to go about it, and there's a way not to go about it. We have seen the war on drugs started 50 years ago. 50
hmm,
years ago.
right.
We have spent more than $1 trillion in the war on drugs. Guess what? Drugs are winning. We've got to figure out a way to address the issue of demand. If we address
Sure,
the
yeah, yeah.
issue of demand through drug treatment, rehabilitation,
Hmm.
um, second chance initiatives like record sealing and expungement for nonviolent offenses, we can start addressing the problems with recidivism, the addiction issue that we face. And we got to remember, addiction is a public health issue. It's not addiction is there may be crimes, other ancillary crimes that happen that come as a result of an addiction, and those I'm not saying those people shouldn't be punished. They probably should, especially depending on the severity of the crime, especially if it's a violent crime. But we have to keep in mind that addiction drives a lot of crime. If we're not addressing the
Right.
underlying cause of addiction, we're creating an entire we're creating more problems for ourselves, because we're susceptible to drug overdoses. That creates workforce implications, things like that.
Sure.
And we're also creating this cycle of crime from which often there is not an escape for these people. And
Yes.
my uncle, who is a
Yeah.
recovering drug addict, who has constantly fought relapses
Mm.
throughout his life, um, you know, he is someone
So
who
this
I
is
love.
personal for you.
Well, this part of it is.
It's
I'm the
personal for a
third.
lot of people.
Yeah, I'm the third generation in my family. My uncle, me, my uncle, and his uncle, who we each lost our fathers at or around the age of 12. So my dad died in 1993, September 1993. Um, my uncle's uncle, my great uncle, was an alcoholic. My uncle was a drug addict. I managed to avoid that stuff. I had a good mom who put the fear of God in me, um, but she kept me on the straight and narrow. So my addiction became politics, sadly. But I know how my life could have turned out,
Yeah.
especially given like I played music. I my most none of my friends none of my friends like in my like my immediate friend group did drugs or drank, but I had plenty of friends who did.
Mhm.
My life could have turned out differently. Um, and I'm not religious, but yeah, I'll use the phrase there, but for the grace of God go I.
Mhm.
Um, that I know my life could have turned out differently. And I really wish people understood. And I'm hoping that if there's one thing people who listen to your podcast will take away, is that we all have an instance in our lives that define us, whether it's our personal, that defines our personal politics, defines our outlook on life, defines whatever. Um, for me, it was the loss of my father. Uh, but some people, we unfortunately are defining a lot of people by their worst mistake, and we're not giving them a path.
Yeah.
Some states are, more than 40 states have record sealing and expungement laws.
Wow.
Some of those laws are misdemeanor only or only some felonies.
Hmm.
Um, we need to broaden and expand those laws. We need
Yes.
more laws like that at the federal level. We
Yes.
need, strong expungement and record sealing statutes. But what frustrates
Can you
me,
hold on one sec? I got a package I think just got delivered. Hold on a sec. Okay. I appreciate you uh, uh, letting me do that.
no worries.
So I'm sorry you got off track. I know you were talking about family issues and you're talking about
Yeah,
why you're, this means a lot to you.
yeah. It's just I really, we need to have pathways to get people back on the right track,
You got to
and
have people
that's
give people hope, right? I mean,
yeah.
can uh I think the connection with guns might be helpful, at least for this conversation. It's interesting. The the depends on what you feel like the police power really should be, and I think the way I approach the police power is that there there's a there's a historic right that the state takes itself to have to manage things like morality,
Mm.
um, health, and safety, right? And that's where you get the obscenity laws. That's where you get the law against walking down the street naked, vandalism and against vandalism. Drugs fits in that, prostitution, stuff like that. All the vice stuff, um, the decency stuff. People don't want to
Yeah.
see that. Police power is taken to be and I'm not saying I agree with that. I'm just saying
Yeah.
that's traditionally what it is, right?
It's
So
how New York City can have a vaccine mandate.
yes, public health
And
gets wrapped into
right.
that. Yeah, that's right. And it used to be flag burning. Of course, no, that's flag burning is interesting because the Supreme Court put an end to that. Where now the police power bumps up against individual liberty, right?
Mhm.
And how that works out and where you draw the line to that is kind of the debate because the police power is all about discretion. It's a discretion of the legislature what they want to do. It's once it's in stone, you got a different kind of discretion, which is judges and prosecutors. And if they have all this stuff to draw from, then a prosecutor that doesn't like you because of your race, or now it's, I guess, gender, or it's like sexual orientation. I guess I'm dating myself now with that term sexual orientation. That's like so 1997. You know, there's this enormous discretion, and that's where all the discrimination comes from, right? I mean, there was an enormous discretion in Jim Crow. It was
Right.
built into the law. It was built into the culture where I can look the other way if I like you, and if I don't, then the entire force of the community comes down upon your head.
Yeah.
And I mean, the way it's supposed to be is that we have laws, right? And then the laws have a certain process. It's very hard to get them through. You have to have a majority. You have to have the executive sign it. The judges have to okay it with when it's litigated. So this discretion issue is one issue, and I see a whole set of issues with the discretion. So like with firearms, when people say we have to do something about it. This goes back to what you were saying about kind of what the career builder congressman, the resume builder is.
Yeah.
Look how many laws I helped pass. They don't ever say, look how many laws I stopped, right? Or, um, you know, that's not on the resume. I stopped this, it's
Yeah.
usually I drafted this, I co-sponsored this. It's all making laws. You have
Right.
so much laws that are being made because the incentive structure is for making laws and it's not for preventing bad ones.
Yeah.
And it's really hard to keep track of all this stuff if you're a voter. I mean, dude, and we have the internet. I mean, but imagine before when we didn't have the research tools that we have available.
Yeah. I
So
mean, there are 10,000 bills introduced in any given Congress. I mean,
that's insane.
it's,
Nobody can keep track of that. And so no wonder there's lobbyists. I mean, they're the only ones that can even keep track of it. And they can't even keep track of they certainly can't keep track of 99% of it. They have their one
yeah.
little area and that's what they keep track of.
Yeah. It's one
And
little
I
area, and 9 times out of 10 where the client's paying them to keep track of it. Yeah.
right. Well, and then
Yeah.
if you're a representative, if you're a member of Congress, I've had candidates for Congress on here and for the state legislature, and I listen to them. I let them do their spiel because they can't help it, right? They do their spiel and they
Yeah.
start talking, right? And I'll let them do that, and then I'll interrupt them and I'll say, you said it was all about leadership. What are you going to do on the first day? And I wait to hear what they're going to say. And then I say, you didn't say what I wanted you to say or what I was hoping you would say, which is coming from a humble place of you have no idea what the hell you're doing because the government is so huge. There's no way you can read all that stuff.
Yeah.
There's no way. So what I'm wondering is how are you going to hire the people that you trust to read it for you and tell you what's really in it?
It, and that's even in and of itself not necessarily a good answer. There's no good answer to that question because when I go
Right.
when I go to the Hill,
I know.
um, I'm meeting people who are between the ages of like 24 and 30,
I know.
or even
Yeah,
maybe
tell us what it's like. Tell us what it's really like. How much
no.
do these people get paid?
So they got a boost in their pay in the legislative branch appropriations bill last year. So they're getting paid, and like I'm the
But this
rare
is a
one.
really expensive place to live.
Oh yeah, you kidding me? Uh,
So when you say they
so,
got a boost in pay, I'm not sure really what that actually means. Like, does
no,
it
yeah,
make a
yeah,
difference?
yeah. The cost of living in DC is it's not as bad as New York, but it's way worse than where I'm from in Atlanta. So you know, like your standard studio apartment in the District of Columbia is going to cost you $1,800 a month. Um,
So, I
so
mean, if you're a teenager and you're thinking, what am I going to do for a living? I would love to be a staff member of a member of Congress. This is not a lucrative career you get into, right?
not
I mean,
initially, no,
it's
not
like saying you want
initially.
to be a public defender or something. I mean, you're
Yeah, it's
it
not
should be it
initially.
should be important, but it's not like as far as the
Well,
pay.
yeah, if you're coming out of college and you're going to work on the Hill, your first job most likely is going to be a staff assistant, and you're going to make 40 grand a year, maybe. Again, the pay scale is better for that than it used to be. It's gone up some, but it's still that's a low rung, office. Like you're a step above an intern, which means you're getting a steady salary, paycheck and all that stuff.
Mhm.
The money, if you're the your senior staff tend to get paid more. And let's keep in mind here, each member gets what we call an MRA. It's the member's representational allowance from which they pay
Right,
their staff
right.
and any other expenses, their district office expenses, things like that. And on the House side, each member gets I think it's 18 staffers, and it's divided between their DC and district offices, if they only have
Now
one.
could the member, do they have the discretion to hire as many people as they want for that number, or is there caps and
Oh,
minimums?
there are regulations around it, and I don't remember the specifics because I never worked on the Hill.
So they
But this
can't
is
just have one person and they get the whole.
no, there are caps on salary, yeah.
Gotcha.
But the caps are higher than they used to be. It used to be that a chief of staff couldn't make more than a member, but that is now no longer the case. There are chiefs who are pulling in more than the member now. It's not substantial. Well, I guess it depends on your definition of substantially. I know of one chief on the Senate side who was earning above $200,000 a year. Members make 174, 177, something like that. So
For their base salary, I think they get, don't they get a per diem of something, some kind?
the
They have
members
some
do.
kind of allowance.
Yeah, the members might have a per diem. The staffers don't.
Okay.
So,
Gotcha.
but
Right.
so the I know in state legislatures per diems are normal, but I don't federally. I don't remember. But they also get all their flights paid for out of their members representational allowance
Okay.
whenever they fly on official business. But so, but
Gotcha.
you're meeting with people who are younger, some barely out of their 30s. Some most of the ones I've met with over the years have been in their mid to late 20s. And look, they're taking on these people. These staffers you meet with have issue sets that are wide ranging, and they even have trouble keeping up with what's coming to the floor and what's not
Right.
coming to the floor. And I mean, and look, we talk about the big bills that are 2,500 pages long and all that. Those are the exception, not the rule.
Right.
But even the debt ceiling package the Republicans passed, a couple weeks ago was it was in excess of 300 pages. I think it was like 340 or something like that. So you're still talking about a bill that takes some time to read and digest.
Yeah.
And that's not easy to do.
No.
And literally, in my old job, when there was a March of 2018, we had the omnibus that was passed then, and we were control effing through that bill with keywords, trying to find different things that we were thinking were going to be in there. So we had to literally sit there, control F, we had about 20 keywords that we were going through to see if they were in the bill.
Mm-hmm.
And it took us 4 or 5 hours to really understand one, to find if the stuff we were looking for was in there, and then you start reading the bill itself to find out what actually is going on, because there's all these other extraneous things that get added onto those bills. But
Right.
most bills are not super long, but even I would even argue a 15-page bill, depending on what it does, if you had to go back and research to find out exactly what it does, that takes time.
Yes,
This
that's
morning
right.
this morning it took me an hour and a half to read through a 14-page bill.
Hmm.
And 14 pages is by itself not a ton.
Right.
But
Right.
14 pages of researching a bill and trying to find and looking at code sections, things like that takes some time.
Let me tell you what my concerns are so far, and you can tell me what you think about this. I'm an educator, and I know the blank looks I get from students when they have too much to do. Because I've been there, I've done it. I've done it
Yeah.
myself. I've been the one giving that blank look because I'm I was a student myself, and I know as an educator, there's no way that the people's representatives can digest that information.
Right.
There's no way. And
But they
I
all
mean, I'm
vote.
talking maybe people that have been there for a really long time. But then you've got, and this is a separate issue, but you've got on the Republican side this fascination with term limits, which totally goes against exactly what I just said, which is that the people that have been there the long time, they're the only ones that know what the hell's going on.
Yeah.
So now you want to exclude everybody who wants to understands what the hell's going on, and that's a recipe for disaster. But I
Okay.
mean, I don't want to talk about term limits if you don't want to. But
but I do. So,
okay, fine.
No, you touched on a hot topic. So like
Yeah.
I have my day job, and then I have a bunch of stuff that I'm involved in that like I do advisory stuff on. And term limits is one that has come up because I do a lot of stuff in like the Article 1 space, just like restoring the legislative branch, all this. And term limits is something that has frequently come up. And I'm like, I don't like term limits. And let me tell you why. One, we have elections. And
There you
two,
go. Hey, what a concept. Amazing. What elections? What are those?
and two, if you want more competition in our elections, you don't need term limits. What you need is more seats that are competitive every 2 years. Right now, we might have, and you can go to Political Report and look at the House race ratings. And I haven't done a count on them myself today or recently, but I know headed into the 2022 midterm elections, there were about 35 seats, give or take, that were considered toss-ups, meaning they could have gone either way. And then you have lean Republicans, leans Democrats, maybe another 30 seats. So you're talking about 65 seats, give or take, that are actually competitive. And there are 435 seats in the House of Representatives. You mean to tell me that three-quarters of, or whatever the math is on that, of House seats, we already know the outcomes.
Mm-hmm.
We're just arguing over these other ones that we don't know what the outcomes of those are going to be.
Right.
And we have to wait to decide.
Yeah.
What's the point of elections? If you want to see more competition, you need to be asking your lawmakers to stop creating districts that benefit one party or the other. And look, that's not going to happen.
It's not going to happen.
But but when you look at it, it's a real disservice to those of us who consider ourselves politically homeless. Yeah. According the most recent Gallup survey I saw said somewhere between 40 and 44% of Americans consider themselves politically independent. That however many it is on the Republican and Democratic side. So, but independents to the clear plurality. Nobody is talking to them. No one is talking to them. And they're completely gettable. The party that talks to those people in the future will be the party that wins majorities. Sure. But unfortunately, both parties are only talking to the margins.
Let me pull something up here and share it with you. Mentioned this is something you mentioned a few minutes ago about restoring Article 1. You remember that?
Yeah, I do.
All right. So be prepared. I'm gonna say prepare yourself for what I'm about to share. Okay, let me because I'm an educator, I want everybody to see how I got to this. Can you see it?
Yeah, I see it.
Okay. All I did was I Googled CRS legislative process, and you're probably wondering what that is. Okay. All you policy wonks know what this is, but I'm talking average people. I want to reach average people. CRS is just the Congressional Research Service. It's a service that was created by Congress and works for Congress. And I taught a course on Congress last semester, and I used this. And you click on it, and it's a document. You can print it out. I like to make it bigger. That's me. All you old people know what I'm talking about. And I'm just scrolling through the document. Look, I want to see what they say what Congress is. Now, this is Congress saying what Congress is. And what I usually do when I have this pulled up is I have Article 1 of the Constitution pulled up right beside it. And I invite my students to take a look at the wording here and see if they see anything that's a problem. And I'll tell you where the problem is. It's in the very first sentence, the very first part of the first sentence. Article 1 of the U.S. Constitution grants all legislative powers to a bicameral Congress. It's not a quiz. I'm not trying to put you on the spot, but do you see
No,
anything missing?
well, one, it doesn't talk about anything about rulemaking authority that goes into the executive branch, which Congress has frequently kicked over to,
Right.
some of its legislative power to rulemaking branches.
Yeah.
So
Well, let me.
that's go ahead.
Yeah, I was gonna just. Okay, sorry, I have the Bible pulled up. Hold on. How did I get the Bible pulled up? Let's do Constitution, Article 1, and wow, how wonderful. Let's get the text. Let's get the text pulled up.
The
Cornell
plain
has
text.
it.
Yeah,
Cornell has it.
if I was in my
My
office,
blood.
I would have my copy of the Constitution sitting right here next to me.
All legislative powers herein granted. They're totally missing herein granted.
Oh,
In the CRS report.
interesting. Yeah.
And see, that is a limitation on government. It's not saying all legislative powers,
Yep.
because the president can veto, then the president has that. And the president has the power to suggest legislation. The State of the Union, for example, that's in the Constitution. So
Well, the State of the Union's in the Constitution, but it doesn't say anything about it actually having to be a big speech.
no,
Um,
but he has the power to suggest, be a legislative leader, and in
mhm.
terms of suggesting policies.
Yep.
But here in Article 1, which creates the Congress, you scroll down and you go down to Section 8,
The things that
and
Congress is actually authorized to do.
these are the particular things that Congress can do, and it's very specific. It's like, coin money, establish post offices, define and punish piracies, declare war, have a navy. And I know this is really basic. This is basic stuff, and there's more advanced topics, like, it doesn't say we can have an air force. So why do we have an air force? Nancy Pelosi mentioned that. But so there is a necessary and proper clause,
Mhm.
and so typically the Democrats like to maximize that and basically make it to where Congress can do anything, basically.
Yep.
But it's just this really bothers me that the Congress of the United States itself takes out the here and granted, because it's like basically saying that doesn't matter, that those powers are given to Congress by the people, and they're limited to what was in the text. And that understanding is just the self-understanding. Congress right here is saying,
Yeah.
no, we have all power. We can
No,
do
and
whatever, anything that's legislative, we can do it.
that's the understanding that a lot of members, even on the Republican side, seem to have. And you mentioned this earlier, and I was
Right.
hoping to find a way to work it in. I'm going to take that liberty now, because you went to Article 1, Section 8. Talked about to regulate commerce amongst the states. That being the Commerce Clause, and there used to be this very specific understanding of what the Commerce Clause was, and then you had Wickard v. Filburn, which related to I think it was the Agricultural Administration, the Agricultural Adjustment Act. I think that's what it was. And you had a farmer who grew too much of a crop, and he was using it for personal consumption. But because that crop took away or affected the commerce, because if he hadn't grown that crop, he would have bought the crop from someone else. It affected the prices of that crop. I think it was corn, and therefore it infringed, or it had something that Congress could regulate, because it affected interstate commerce. And there we have this huge hole blew in the Constitution because of the Wickard case and the interpretation of the Commerce Clause, further diminished or further watered down with the Raich v. Gonzalez case, I think in 2003 or 2005, which dealt with California's medical marijuana law. And unfortunately, Justice Scalia was in the majority on that, which further watered down the understanding of the Commerce Clause. And yeah,
My understanding is, very limited on the Commerce Clause, but my understanding is that um, that I think Senator Whitehouse threw a fit about this during the Kavanaugh
I'm sure
hearing.
he did.
Actually, it was probably the Gorsuch hearing too. But I made myself suffer through all those all those theatrics. But he made a big deal about the what he called the Roberts Five. And that's Justice Roberts and the Republicans, most of the Republicans on the court. My understanding was that um, it's been Republican justices that have been the only ones pushing back on the expansion of the Commerce Clause at all, starting with the Lopez case in 1995. That was a gun case. This is a gun-free zone case. I don't know
I
if you
remember the
remember that.
Lopez. Yeah, I remember the Lopez case. So
Yeah. But
Raish.
it was only Republicans on the on that side.
So I'm pulling up Raish v. Gonzalez now, but
Okay.
I remember a lot of us were frustrated about that case because of the expansion of the Commerce Clause um, that came as a result of it. And so it was Gonzalez v. Raish.
Uh-huh.
So I had it backwards. Gonzalez v. Raish, and the question in the case. I don't see the question here. So
I'm just looking at the
the holding was Congress may ban the use of cannabis even if states approve it for medicinal purposes. And in the majority, you had Stevens, Kennedy, Souter, Ginsburg, Breyer, and concurrence in judgment, Scalia. And then dissent was O'Connor, joined by Rehnquist, Thomas, and all but part 3. And then Thomas filed his own his own dissent, in which I think if memory serves, he said, he disagreed with marijuana usage or drug usage, but he cautioned the court on further expanding the Commerce Clause, which was the end result of that of that judgment.
Right.
And so, granted, everyone on the conservative side except for Scalia opposed it. But and look,
yes.
Yeah, and
yeah. So let me just I think what I'm saying is that there is ever since the New Deal, right? Which is the Wickard versus Filburn case and all those, expansion of the federal control of the economy and all sorts of criminality,
it's the end of the end of the Lochner era, more specifically.
So you got the NFA, for example, the National Firearms Act in 1934, but this expansion of the federal police power was at that time during the New Deal a very partisan issue. I think it was mainly Democrats. Well, Democrats were in control of the whole thing. The New Deal was a Democrat thing, and the Wickard versus Filburn thing, it was Democrat appointees that were Roosevelt appointees, and so you had that in 1941, and it was only like 50 some years later in 1995 that you had any pushback on that at all. And now you're right. The Republicans are not purebred pushing back on this stuff. Like, okay, let me just pull up the Lopez case really quick.
Yeah.
Just really quick.
I mean, no, and just while you're looking that up, I'll say that and so you had different eras of the court, but obviously you had this Lochner era, which basically shot down a lot of state-based economic regulation and pushed back on those police powers of the state. And then the Lochner era ends with West Coast Parish Company in 1937, which a lot of people consider the switch in time that saved the nine, because at the time FDR was developing his court packing scheme.
Right.
And by the
Right.
way, I should note, Due Process Institute doesn't work on any of this. This is
Yes,
just
I totally get it. Totally get it.
my,
Totally get it.
this is just
But
my own
just
personal fun
we're just,
times.
but if anybody's concerned about drug issues, right? And due process and criminality, and if you're interested in that, you have to have at least some start getting into the details of what has been going on with the Commerce Clause during the 1900s,
Yep.
and what where kind of try to get the story. The broad story is that the and my understanding is that the Democrats it was basically their idea that we could just do whatever we want, basically. And the only pushback in the 90s, actually there was another pushback, I believe, in Prince versus United States, which was, I think, 1997. We actually
I
had
don't.
the guy that won that case. He came on the
Oh
podcast.
wow, that's cool.
Yeah, his name is Stephen Hallbrook, and that was a federal
Oh yeah.
commandeering. Yeah, that's a federal commandeering case. So that's another one, but that was all Republicans too on that side. So you have the well, not the Roberts Five, but you have the Rehnquist Five, I guess, would be what Senator Whitehouse would say about this case, maybe. But and then you have the Democrats on the dissent. But
Yep.
so it seems like the Democrats are always wanting an expansion. Seems
Mhm.
well, actually, besides you're saying besides race, the race
Besides
case.
race,
So besides on
but
drugs, on drugs they don't like the Commerce Clause. Is that
that's
right?
that's yeah. I
And the
mean,
Republicans are kind of like, I don't know.
yeah, and it's an interesting. It really is an interesting take on Scalia, who's made himself the originalist of the court. He and Thomas, but
Mm-hmm.
Scalise was considered an originalist, and here he is, fighting to expand the Commerce Clause from my perspective, to achieve a policy outcome. It wasn't based on a
Right.
legal outcome; it was based on a policy outcome that he desired, and that is not how originalism works.
If you want to pull up the actual case, I use Google Scholar, and something like the Raich case. Was it Gonzalez versus Raich?
Gonzalez versus Raich.
Okay. Yeah, it's going to pull right up, and then you can have the actual text, as the kids say, the actual text.
The actual text.
The literal, this is literally what
This
it
is
is.
literally the text
And
of
you can print
Gonzalez
this
v.
out. I
Raich.
like to print this out.
I have not made the transition over to digital like most of my millennial peers. My girlfriend and I constantly argue whether we're exennials or millennials. I consider myself a millennial. She considers herself an exennial, and I'm 11 days older than her. So, but no, I always prefer hard copies, and I tried the digital book thing for a while and couldn't get into it. So,
Oh yeah.
yeah, I prefer hard copies of books, which sucks because we're buying a house and I have to move all that crap. So,
I feel your pain. I
yeah,
know your
but
pain.
no, and I gotta go in like 5 minutes, but I just wanted to just say, like, look, when it comes to going back to what I work on, and some of the things we discussed, mens rea and overcriminalization, and are things we work on, and the acquitted conduct sentencing, certainly something that we work on. And we got that bill out of the House last Congress, and we got it out of the Judiciary Committee by voice vote. I think we had fewer than 15 who voted against us on the House floor. But
What was that bill again?
That was the Prohibiting Punishment of Acquitted Conduct Act. So that changes the acquitted conduct sentencing that's currently in federal law. But we couldn't get the Senate to take it up. But most of what I deal with on a day-to-day basis is largely federal drug sentencing and second chance related bills.
Gotcha.
So
Gotcha.
let me give your audience a quick rundown of some bills. So the first one is the Equal Act, which is equalizes the treatment between crack cocaine and powder cocaine.
Oh,
That
okay.
is, yeah, that's a bill
I've heard
that,
of that
and
issue.
there,
Yeah.
yeah, there's been a long history of that type of sentencing, and we're working to eliminate the sentencing disparity between those two.
I personally use crack. So would this help me?
Potentially, yeah, it would. If you're trafficking in large, if you have more than 28 grams, you're subject to the 5-year mandatory minimum sentence. So,
I'm going to follow
so
this up. I'm going to follow
yeah,
this up.
but if you have 5 grams of meth, you're in even more trouble. I mean,
Oh, is that
that
right?
is a yeah. I'm not working on that issue, but that's a 5-year mandatory minimum sentence for 5 grams of
Okay.
meth. Um, and then the Clean Slate Act, which is record sealing for simple possession and marijuana related offenses, all have to be nonviolent. We also provide a petition process. The simple possession and marijuana offenses, that's automatic record sealing. But there's a petition process that would be set up for nonviolent offenses, not drug offenses, any nonviolent offense, when we specify what exclusions there are, all that stuff. The Kenneth P. Thompson Begin Again Act, which is expungement for simple possession for any individuals over the age of 18 or 18 or older. The Fresh Start Act, which would create a federal grant program for states to do automatic record sealing and expungement. And then the Smarter Pretrial for Drug Charges Act, which is currently in federal law, if you have a sentence for felony drugs that is 10 years or longer, you are presumed not to get bail. This would simply take away that presumption. And it's in the same class as murder. And like there's only like a couple, there's like a few there are a few felonies that are treated that way. One of them's murder. The other is felony drugs. Any drug felony that has a sentence of 10 years or more.
Wow.
Examples. So we're working to get rid of to change that presumption. That's all that bill would do.
How do people find your organization if they want to support it?
Sure, you can go to so you can go to idueprocess.org, the letter idueprocess.org. You can also find us on Twitter at idueprocess. You can find me on Twitter at PYE at Pi, where I tweet.
Are you serious? That's your Twitter account?
Yeah.
Wow, that's the shortest one I've ever heard of.
So I had to actually contact Twitter to get that because someone else had it, but it was an active account. And the guy I knew at Twitter like hooked me up, and
nice. Was that Elon Musk day?
Oh yeah, that was like 7 or 8 years ago. I doubt that was when Twitter was responsive. They're not responsive. They haven't been responsive since before the Elon takeover.
Okay.
So and then look, there are other bills that I could talk about. I could spend another hour or two talking to you about all of these things. But just please check us out.
So far, everything you've said, I can't think of anything that I wouldn't be at least interested in, if not excited about.
Well, and I have a personal Substack as well.
Oh, you do? Okay.
Yeah, I have 2 Substack addresses to give out real fast. My personal one is exiledpolicy.substack.com. That is not affiliated with the Due Process Institute. That's just where I rant and whine about everything that's not related to criminal justice. And then you also have the Due Process Institute Substack, which is dueprocess.substack.com. There's a newsletter there that I do every week on what's happening in Congress. So and I only do it when Congress is in session, and I try to keep it as minimal as possible. But Professor, thank you so much for your time.
Thank you, Jason. I appreciate it. And I just want to say, this is very important. Anybody interested in over-criminalization, you have to theoretically get clear about what criminalization is, what should be criminalized. If you don't have that, you're not going to be able to see what over-criminalization is. So this is very important work. Thank you, Jason Pai of the Due Process Institute, for coming on.
Thank you, Professor. I appreciate it.
See ya.
See ya.